So it's really my pleasure to have Professor David Dyzenhaus for our third conference here at the University of São Paulo Law School. And this is especially for the students of the graduate course I'm offering this semester on the rule of law. It's a special opportunity for them. I guess many of them will be coming short. And I'd like also, since it's the last conference, to thank many people who were absolutely essential for the organization of this meeting, for bringing Professor Dyzenhaus here at USP, especially Martin Pettis, Iago Mina, Rafael Maffei, Arthur Prado, and also our graduate office, ProEx program that funded David's coming here. I'd like also to say that this is part of a program that we call this the third version of the workshop on legal, political, and moral philosophy that we have here at the University of São Paulo. And we are also very happy to say that we have more news to come. Next, in about 10 days, Professor Andrei Marmor will be with us too, discussing many issues on contemporary legal philosophy, and also the issue of rule of law. So it will be a privilege. So I'd like to thank you, Professor Dyzenhaus, once again for being with us and to offering your generosity and your experience and your ideas with our students. So I'll give the word to Iago.
Yeah, since this is the third day, I think most people already know you, Professor, but I'll just make a quick introduction anyway for those who are watching us from home. Professor David Dyzenhaus is Professor of Law and Philosophy at the University of Toronto and a Fellow of Royal Society of Canada. His work focuses mainly on political and legal theory, and right now, mainly the issue of legality and the rule of law. His talk today will center on the topic of the rule of law in times of exception. So without further ado, I will pass the word to Professor Dyzenhaus.
Oh, can you hear me with this? Yeah. There we go. I think that's better. Well, thank you very much for the introduction. And I want to thank all of the people whom you mentioned earlier, but you didn't mention yourself, for this week in Sao Paulo. I've had 3 occasions to write to people about this week. One, I've been corresponding with someone who was here a while ago, Kristen Rundle, and I told her that I was actually overwhelmed by the hospitality, and she agreed that the hospitality is overwhelming. I told my wife this morning, and also an Italian friend, that what Brazilians do when you visit them is equal to what they do in Genoa when I go there. And it's just been fantastic here. Not just the socializing, but also the opportunity to talk to the various audiences, because the questions have been great. And I found on my last trip here that I learned more from audiences where there is some kind of common experience. I come from South Africa. I grew up under an authoritarian regime. And if I talk to people who come from this part of the world, where there's at least some memory of dictatorship, even if you weren't living under the Brazilian dictatorship, this just does give a sense, I think, of how important issues are, like the rule of law and legality, in countries where one cannot take liberal democracy for granted. So I'm very pleased that for this last session, that I was invited to participate in a course where you read Gerald Postmer's Law's Rule. So I want to, yeah. Yeah, so I want to say a little bit about Gerald Postmer. Postmer has been a huge influence on me. I read his book, his first book, I think, when I was a graduate student, Bentham and the Common Law Tradition, which was, as far as I knew, the first attempt to set contemporary debates in philosophy of law within a historical context. And in a way, that book opened my eyes to a different way of doing a philosophy of law from the traditional analytic way of doing philosophy of law, where one just cares about argument. So in all of my work, really over the last however many years, what I've tried to do is make progress in philosophy of law and in political philosophy by looking at what people have said in the past and then trying to work out what light that sheds on the present. And in a way, Waldron and others I joined them in what I think of as a kind of common project. I only learned quite a long time after I acquired this book that if you ever get to the acknowledgement section, which is right at the end of the book, that Postuma acknowledges three people. And this was a matter of great happiness for me when I saw that I was one of the three. I wasn't expecting this, so it was a special joy for me to see that he acknowledged my influence on his work. And I didn't know about this because he never refers to me. But I thought that maybe it's because actually we think so much the same about a lot of things that there's no need to refer to each other. And the other two people he mentions, an Australian Polish legal theorist, Martin Krieger, who I think is probably the greatest theorist of the rule of law of the last 40 years or so, and Jeremy Waldron. We've all been involved in a project of trying to make sense of the rule of law, which gets away from the standard positivist understanding of the rule of law, that the rule of law is something that makes of law something that's valuable in a purely instrumental way. So we've all tried to work out a different conception of the rule of law, and I think that's what gives us a common project, a project which I called, not in the paper, but I'll get to this later in a slide, the Rule of Law Project. And so when we get to the conclusion of the chapter of Postuma's book, which I chose to deal with to some extent in my presentation today, what Postuma says on the slide is something that I wish I could have written, because he's more articulate than I am, and it's exactly how I would like to conclude a chapter on executive power unleashed. And what I want to emphasize here is really just two things, or maybe three things. One is Postuma, like me, thinks that the rule of law can control executive action in a time of emergency. But he does also think that it's important to look at challenges to the idea that the rule of law can exert this kind of control. And in order to respond to those challenges, one has to articulate a political ideal that one thinks that the rule of law serves. So when it comes to that, I agree completely. But I thought that in order to have some disagreement between Postuma and myself, it would be useful to focus on someone who only makes maybe 3 appearances in his chapter, and that is Carl Schmitt. And I'm not sure that Postuma really confronts Schmitt's challenge to the claim that the rule of law can control the executive in a time of emergency. So when I say I'm not sure about this, maybe he can, but I thought I would try to be a little bit provocative today and say that actually he fails completely to confront Schmitt's challenge. So while I agree with his conclusion, I think he would need more argument in order to show how he responds to Schmitt. So here we get Carl Schmitt and the famous sentence with which he starts his book, Political Theology, sovereign is he who decides on the exception. It's quite hard to translate the sentence in German into English. And what this English translation misses out on is the German word über. So that's George Schwab, the translator, translated as on. And if one looks at the German sentence with which Schmitt started political theology, one can see that in the sentence, he deliberately puts an ambiguity at the heart of his claim. And the ambiguity is between 2 claims. The one is that the sovereign gets to decide how to respond to a state of exception. But actually, the more important claim for Schmitt is the other one, and that is that the sovereign gets to decide when there's a state of exception. So it's entirely up to the sovereign to decide not only how to respond, but also when there's a situation that demands the kind of response that the sovereign thinks is appropriate. It's actually a matter of some amazement to me how much traction, how much presence Schmitt has in contemporary debates. When I started working on him, he was virtually unknown, at least in the English-speaking world. But when I was looking for the German sentence today to make sure that I remembered it right, I discovered that if you put into the internet 2 words in English, sovereign is, you immediately get the Schmitt sentence. And if you put the German equivalent in souverän ist, you immediately get the German sentence. That's all you need to get the first sentence of Schmitt's political theology. And if one puts a Google search into something like The Guardian, the main English newspaper, or the New York Times, or the Washington Post, you will find that there are references to Schmitt there. So Schmitt has, in a way, entered public debate. And I find this really remarkable. And I've spent a lot of time trying to persuade people that we should keep away from Schmitt, whom I regard as a highly dangerous figure. But nevertheless, it is the case that he is really influential. And one of the reasons he's influential is that he does pose quite a powerful challenge to the way that liberals like to think, if they so think, that the rule of law can control the executive during a state of exception or emergency. So now I just want to move to Schmitt's main opponent in the debates in Weimar about these issues. And that's, of course, Hans Kelsen, who I always assume is well known to an audience in this part of the world. I know that students often resent the fact that, as I understand it, often in their first year of law school in Brazil, they have inflicted on them large chunks of Kelsen's main works. But I actually think that you're privileged to encounter Kelsen as soon as possible in your law degree. The book from which I take this sentence from Kelsen is a book that's not all that well known. I had a long quotation from this book in my first presentation here. It's his book on sovereignty that he wrote at the beginning of the 1920s. It's a book about international law. And at the end of the book, Kelsen comes out with this sentence. He says the concept of sovereignty should be radically suppressed. In a way, the argument of the book is that we need to get rid of the idea of sovereignty, because every time sovereignty is introduced into a debate about judicial review, the rule of law, the relationship between international law and state law, it does a certain kind of political work that Kelsen regards as pernicious. And so he thinks that one should get rid of the idea of sovereignty altogether if one wants to make progress in legal theory. Now, these debates about the rule of law, about sovereignty, the state of exception, might seem a little esoteric, maybe not to this audience, as I suggested right at the beginning of my presentation, but they certainly aren't. And on the next slide, what we have is a scene, I'm not exactly sure, but I think it's probably pretty close to the German parliament in Berlin in 1932. And these are people looking at a poster, which if you can make it out at the top of the poster, of course, you can't make out the small print. It says this is a decree of the President of the Reich. And this is a really significant moment at the end of the Weimar Republic, because the President, Hindenburg, used Article 48, which was the emergency powers provision of the Weimar Constitution, to issue a decree at the behest of the federal cabinet, which was dominated by right-wing aristocrats who wanted to get rid of democracy. And the effect of the decree was to seize the machinery of government in Prussia. Now, as many of you might know, Prussia was the largest state within the German federal system. It was also the bastion of the Social Democratic Party. And so getting control of the machinery of government in Prussia was very important for right-wing Germans who wanted to get rid of the Social Democratic Party, and actually also of parliamentary rule in general, of the institutions of democratic government in Germany. And they thought this was their first step to actually being able to deal with the forces that were further to the right than they were, that is the Nazi Party. So they thought if they got rid of the Social Democratic Party's hold on power in Prussia, they would be able to deal both with the Nazi Party and also with the Communist Party, because they would gather power into their own hands and then be able to wield power effectively against their enemies. This, of course, didn't work because Hitler outmaneuvered them and seized power himself in 1933. But in 1932, before it became clear that Hitler was going to come to power, there was this decree commonly known in Germany as the coup against Prussia. And the Social Democratic Party in Berlin chose to contest this decree in court. And there was a court case in which Schmidt appeared. Kelsen commented on the case. They were both at the University of Cologne at that time as law professors. And in effect, the Social Democrats lost the case. And this is regarded by German historians as a fairly significant moment in the rise to power of Hitler the next year. So I just wanted to make the point that the kinds of arguments that Schmidt and others were involved in, particularly Schmidt's contest with Kelsen in the 1930s, were actually of great practical significance. And there was a debate, which some of you may know, in the early 1930s between Schmidt and Kelsen about who should be the guardian of the Constitution, with Schmidt arguing that only the president could be the guardian of the Constitution, and Kelsen trying to make arguments that actually no, the court, the Supreme Court, which would decide such matters, should be regarded as the guardian of the Constitution. Right, so where I want to go now is to the problem that I think that liberalism confronts in making the claim that the rule of law can deal with states of emergency. And the problem goes all the way back to one of the great philosophers of liberalism, that is John Locke. So Locke, in his treatise on government, is regarded as having set out perhaps the first comprehensive understanding of the liberal commitment to the rule of law. And he there extols the virtues of the rule of law, of the advantages to liberty of life under, as he puts it, settled, standing, legislated rules, common to all, in contrast to the inconstant, uncertain, unknown, arbitrary will of another man. So there we get the classic distinction between the rule of law and the rule of arbitrary power, or the rule of men. And Locke is regarded as having been responsible for setting out this distinction in his treatise on government. But it's also the case that in the same book, Locke insists that in emergencies or states of exception, the government must have a prerogative, by which he means a legally unconstrained power to act according to discretion for the public good without the prescription of the law, and sometimes even against it. So Locke builds in, as it were, into his understanding of constitutional order, this authority of the sovereign, whom he calls the prince, to act against law if the sovereign regards this as necessary in order to deal with an emergency situation. And like Schmidt, I think Locke quite clearly thinks that it's up to the sovereign to decide when there's a situation such that these drastic measures are required. So now I want to turn to Schmidt and what I call Schmidt's critique of liberal legalism. And we'll see in a moment that I think this is a distinct critique from Schmidt's critique of liberalism per se, and it's important, I think, to see the distinction. So Schmitt says in Political Theology that the exception was something, as he puts it, incommensurable to John Locke's doctrine of the constitutional state and the rationalist 18th century. So there the claim is that this liberal doctrine of the constitutional state that we find in Locke is something that can't be put on the same level as the state of exception. And Schmitt goes on to say this kind of rationalist tendency, which he thinks Locke began, ignores the emergency, as exemplified in his great opponent, Kelsen, who does not know what to do with it. So both Locke and Kelsen just do not know how to respond to a state of exception or emergency. And we can see this if we go all the way back to the slide with the sentence from Kelsen, because he says we should get rid of the doctrine of sovereignty. So his view is it's kind of nonsense to think that the sovereign can decide in a state of exception, because this conception of sovereignty plays no role in legal and constitutional theory, or should play no role. So I think it's interesting that Schmitt ignores, in concept of the political theology, this idea of the prerogative, which is clearly stated in Locke. And I think he ignores it because he thinks that this is just a liberal admission that there will be states of emergency which can't be dealt with through law. And then we get the third claim that Schmitt makes in his critique of liberal legalism. And this claim says liberal constitutionalism can try to anticipate the exception and can suspend itself while seeking to regulate the exception as precisely as possible by spelling out in detail the case in which law suspends itself. So there, what I take Schmitt to be saying is, well, the claim isn't that liberal thinkers are doomed to be completely unaware of the possibility of a state of exception. If they become aware, they can try to deal with states of exception in advance, and they can do so by putting in place legal controls that will manage the state of exception in accordance with rule of law principles. And I think the question we have to ask is whether there's a tension in Schmitt here, particularly between claims 2 and 3, because claim 2 seems to say the liberal rationalist tendency just can't even acknowledge the state of exception. Claim 3 seems to say, well, it can acknowledge it and can try to deal with the state of exception, but somehow will fail. I don't think Schmitt thought that there was any tension between these claims, and I want to explain why. But before I get there, I just want to go back to Postumer for a moment. I think the problem in Postumer's chapter is he ignores this tension, or doesn't actually see it, between claims 2 and 3. And he doesn't understand that Schmitt's argument is, and I'm going to use an English expression now, which I don't know means something to everyone here, that liberalism is damned if it does and damned if it doesn't. Does this expression mean something to people here? Whatever liberalism does, it's doomed. Why? If it ignores the exception will happen, and that will be the end of liberalism. If it tries to deal with the exception through legal means, the exception will happen, the legal means won't be sufficient to deal with it, and liberalism is doomed. So I think that's Schmitt's claim, and I think Postumer fails to see that. I think he also fails to see what the real basis is, the normative basis of Schmitt's argument. Because when Postumer confronts what he calls the normative argument against using the rule of law to deal with a state of exception, he understands that normative argument as saying, well, we could deal with the state of exception through mechanisms that are in accordance with the rule of law, but it would be better to do something else. And that's not Schmitt's argument. And I think Postumer misses the challenge of Schmitt, therefore, altogether. And I think one can only understand Schmitt's argument if one understands what the normative basis is of his claims. So this is Schmitt's critique of liberalism. So not of liberal legalism, but of liberalism per se. And something which might be familiar to you all is Schmitt's concept of the political. Schmitt says in the concept of the political that the political is the site of an existential struggle between friend and enemy. And it's quite clear that he thinks this struggle can only be resolved by the decision of the leader or sovereign, made on the basis of a vision of the substantive homogeneity of the Volk, which I put in German just because Volk never translates well into an English word like nation. I don't know whether the same is true of the Portuguese equivalent. And the mark of success of the leader is that he attracts that he attracts their acclaim. They applaud what he's done. And Schmitt says of liberalism that it requires that the state take no stand on this kind of existential question about the substance of the good that Schmitt regards as the stuff of politics. And in taking no stand, it makes the criterion of the legitimacy of laws, whether they have been enacted in accordance with the formal procedures stipulated for enactment, and the criterion for the legitimacy of official acts, whether the officials have been authorized to act by such laws. And when Schmitt makes this kind of claim, he clearly has Kelsen in his sights. Kelsen's formalism. Why? Because he thinks that Kelsen's formalism has no criterion of legitimacy other than criteria of validity. So anything that can be validly done is considered legitimate. This is his claim against Kelsen. And that for Schmitt allows him to combine the two critiques, the critique of liberal legalism and the critique of liberalism itself. So as I understand his argument, the liberal aspiration is that government according to law, conceived in this way, will serve liberty by making state action predictable in advance. It will also serve equality. However, this aspiration, Schmitt thinks, is vulnerable to being undermined. First, because it requires that any substantive content injected into law by a group that has won political power in the legislature must be deemed to be legitimate so long as the law has been properly enacted. Absurdly, then, illiberal content must be deemed to be legitimate. And perhaps one can see examples of this kind of phenomenon in places which are officially committed to something like illiberal democracy. So in Hungary, the idea that as long as you work within the law in some sense, even if one's stretching the idea of what it is to work within the law, what one achieves through working through the law must be deemed to be legitimate, even if it's illiberal. And Schmitt thinks this is a particular vulnerability of liberalism. And similarly, an official who is authorized by law to act as he deems fit, that is arbitrarily, is by definition and again absurdly deemed to be acting legitimately. So as long as someone is officially authorized to act, even if that person is officially authorized to act in arbitrary ways, then liberals must suppose that everything that official does is done according to law. And Schmitt spots that as another weakness in liberalism. And I think that Schmitt's conclusion, therefore, is that there's no tension between his claims 2 and 3. Liberalism, he thinks, will attempt to regulate the exception, but will fail. That failure permits its enemy to emerge from within. What is liberalism's enemy? Any political ideology that successfully makes the distinction between friend and enemy. So now I want to actually go back to Wednesday and to your question to me in the question and answer session, because my presentation then was on the basis of a paper called Positivism and Totalitarianism. And Professor Macedo pointed out to me that actually my paper seemed to be much more about authoritarianism than about totalitarianism, which a criticism which I just had to accept. It was embarrassing for me a little bit that I'd written a paper which should have had a different title, but I tried to explain it away by saying, perhaps not a very good explanation. That was the title that was given to me, so I was just keeping to my mandate. So not a good excuse. I probably could have insisted that they change the title, but it didn't occur to me then. And why is this distinction important? I think it's important to actually understanding Schmitt. because Schmidt was an authoritarian, but I think not a totalitarian. And as I think I responded to you on Wednesday, Schmidt, and this goes back to the slide about the coup against Prussia, Schmidt wanted a group of mostly Catholic right-wing aristocrats to win power in Germany. And if they won power, his vision of the future for Germany is that you would get rid of parliamentary democracy, you would have power exercised by these right-wing aristocrats. And one of the things they would do is a retreat from control over the economy and just ensure that the state enforced the correct values on which one could build a vision of the German folk that Schmidt thought was appropriate. Whereas the Nazis, I think, had a completely different vision. The completely different vision was that they wanted a total state that would dominate every area of life, including the social and the economic. So this was against Schmidt's, if you like, personal view of what the ideal state would look like. But when the Nazi state came along, it was the case that he had no principled reason for rejecting the Nazi vision. Why? Because as I tried to indicate in the sentence just above the note, for Schmidt, it's a case that any political ideology that successfully makes a distinction between friend and enemy must be regarded as legitimate. So when the Nazis came along in 1933, Schmidt signs up to the Nazi party, becomes their official jurist until he falls out of favor with them. And in a real way, I think one can understand what he does as just Schmidt, who was a thoroughly nasty person, just wanting to curry favor with the regime that had come to power. But I think it's also the case that he had no principled reason for objecting to the Nazis. Why? Because he thought that any political ideology that successfully makes this friend-enemy distinction is legitimate. Right, so what I've tried to do so far is to set out Schmidt's argument and to explain why I think Postuma doesn't really respond to Schmidt's challenge. And now what I want to go through is the various responses that people have tried to put together in response to Schmidt. And the first response is not actually a response that comes from liberals. It comes more from left-wing radical Democrats. And I use this term in no pejorative way, because I actually admire the work of many of these people, but they're no fans of liberalism. So I don't label them liberal. They're certainly on the left wing, and they are radical Democrats, which I think is actually a good thing to be. So this is why I choose the title for them. So the left-wing radical Democrats, as I understand their position, accept the combination of Schmidt's claims, the claim against liberal legalism and the claim against liberalism itself, because they agree with Schmidt that liberalism constrains the space of the political, or as some of them put it, of agonistic conflictual politics. In a way, these radical Democrats think that that liberalism exercises a pernicious constraint on politics. We've got to get rid of that constraint if we're going to have true democracy. So they ally themselves with Schmidt to this extent. And I think the problem for the left-wing radical Democrats is that they have the same view as right-wing populists, as well as Catholic natural law reactionaries like John Finnis in Oxford and Adrian Vermeule at Harvard. And if you looked at the very polemical paper that I published in Aeon about John Finnis and Schmidt, you'll have encountered my views on this movement in contemporary constitutional and political thought. And I think if you accept this combination of Schmidt's claims, you have to rest your faith on a kind of bet that your side will win. And moreover, I think it requires accepting something that Schmidt argued for in his conclusion, that democracy reduces to what I think of as an existential bond between ruler and ruled, with the political community bounded some idea of thick ethical values. It requires, that is, accepting what I call in that piece in Aeon, Lawyer for the Strongman, Schmittian logic. It doesn't matter if you've read Schmitt or not. There is a kind of logic to a kind of argument, which, if you accept it, commits you to the same views as Schmitt. And I think that's highly problematic for this left-wing radical democratic position. And in the note that I have on the slide, this is something that I'd already mentioned, that Schmitt argued, or suggested in earlier, I didn't actually say this, that when Schmitt made his argument in the case that followed the coup against Prussia, part of his argument, indeed the main part of his argument, was that parliamentary government was the main source of the threat to Weimar democracy, responsible, that is, for the state of emergency that required the decree under Article 48. This isn't explicitly Schmitt's claim before the court, but it was pointed out in argument before the court by my favorite German public law theorist, who argued for the Prussian Social Democratic Party before the court, Hermann Heller. He pointed out to the court that what Schmitt was really arguing is that there was a state of emergency. The source of the state of emergency was parliamentary democracy, and therefore the cure for the problems of Weimar was to get rid of the Weimar constitution. And Kelsen had much the same reaction to Schmitt. Right, now I'll get to the second response, and this was inspired by a question, actually a discussion at lunch after one of my sessions. I think you'll all recognize the man on my slide. So this is the response that's given by the group that I call liberal neo-Lockeans. And liberal neo-Lockeans, as I understand them, accept the critique of liberal legalism, but reject the critique of liberalism itself. So in accepting the critique of liberal legalism, they agree with Schmitt that one cannot respond effectively to a state of emergency in accordance with the rule of law. But they don't think that that's fatal to liberalism. Why? Because if you have a liberal government in power, it can save itself, it can save liberalism by assuming for the moment extra legal powers. So they embrace one part of Schmitt's argument, but not the other. And it occurred to me after listening to what people told me about your Supreme Court during the Bolsonaro era, that maybe this judge, whose name I'll probably mispronounce, Alexandra de Moraes, how does one say it? That maybe he is a liberal neo-Lockean. So here what we have is a quotation from the New York Times article about him, talking about some of the things that he did during the Bolsonaro era. And they say that this amounted to a raw display of judicial force that crowned a trend years in the making. Brazil's Supreme Court has drastically expanded its power to counter the anti-democratic stances of Mr. Bolsonaro and his supporters. So the claim there is that when the Supreme Court did what it did, it was assuming a kind of extra legal authority in order to save a liberal democracy. And that is precisely, I think, the liberal neo-Lockean position. But I think they have, this position has the same problem as perhaps the left-wing radical Democrats, in that if with Locke you grant those who wield ultimate power the authority to decide on and in the state of exception, you also grant them the authority and then perhaps the legitimacy to put in place whatever political vision they think is appropriate. And that, I think, concedes everything to Schmitt. So now we get to, so let me just say something quickly about Postuma again, since this is within a class that read carefully Postuma's book. I think that Postuma is a little bit ambivalent between the second response, that's a neo-Lockean response, and the third response, which I'm going to articulate in a moment. But I do think that what he really embraces, and that's the point of the slide, which has his conclusion to his chapter on the state of emergency challenge to the rule of law, his conclusion is supported only by the third response to Schmidt, which is, of course, mine, right? So I have to win. And so here's response number 3. So response number 3 is the response of what I called earlier in my introduction to the presentation, the Rule of Law Project. And the Rule of Law Project accepts a number of propositions. One is it accepts what I call the compulsion of legality. And that compulsion of legality is a permanent feature of advanced liberal democracies. What is the compulsion of legality? The compulsion of legality is, I think, that liberal democracies are under an obligation to respond to states of emergencies or states of exception through law. They don't have the option, if they want to remain liberal democracies, of assuming an extra legal power of the thought that Schmidt thought appropriate and that the liberal neo-Lockeans think is appropriate. But I do want to admit, and this is the second item which I accept, that this compulsion of legality can set in motion 2 very different, what I call, cycles of legality. So on the one hand, you have what I call a virtuous cycle. And in the virtuous cycle, what one gets in responding to an emergency is that the institutions of legal order cooperate in devising controls on public actors that ensure that their decisions comply with the principle of legality that exerts a political moral discipline on government. So that happens if everything turns out well. One gets the virtuous cycle. But in the other cycle, which I call the empty cycle, the content of legality is understood in an ever more formal or vacuous manner, resulting in the mere appearance or even the pretense of legality. So I do want to acknowledge, in acknowledging the possibility of this empty cycle, that Schmidt was onto something when he said that if liberal democracies try to deal with states of emergency through law, what one might get is something completely empty, that is the appearance of legality, but no substance to legality. So that's an ever-present danger, but I don't think it's a danger that has to happen. I think virtuous cycles are perfectly possible. So here I just want to have a slide which sets out something else that I accept in trying to articulate this rule of law project, and I think that Postuma also quite clearly accepts. So this quotation is from a great American judge, Learned Hand. It's a wonderful name, but that is actually his name, Learned Hand. And in 1941, at a time when the Second World War was going very badly for the Allies, Hand was one of a few people who were invited to address a huge crowd in Central Park. And he gave this talk called The Spirit of Liberty. And at the end, towards the end of the talk, he has this quotation, which is very well known in the United States. He says, what do we mean when we say that, first of all, we seek liberty? I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. These are false hopes, believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. Rather pessimistic in one sense, right? So this is a leading US judge saying, don't count on the likes of me to save you. If the only way you'll be saved is if you out there are also lovers of liberty. And I think both Postuma and I accept that in the end, what really counts is whether people are committed to liberty, committed to liberal democracy. And let me give you just a quick example. I think that when Trump and his base tried to effect what amounted to a coup against democracy after the last election, So I use the word coup not only because it was used to describe what Trump and his base tried to do, but also to remind you of this title that's given to what happened in 1932 in Germany, the coup against Prussia. I think what saved the United States of America as a democracy was not anything that Democrats did, and perhaps really not anything that the courts did, although the courts helped, but what Republican officials did in various states when they thought that their duty as public officials was to count the votes in a way that had been prescribed by law. And I think that without a commitment to liberty in the hearts of Republican officials, the United States of America might look very different today. So I think that anyone who's going to defend the proposition that the rule of law can control states of emergency has to take into account that it's not just the institutions that are going to save us. There has to be a public out there, including officials, who are committed to the ideal of the rule of law. But if one has that commitment in place, I think one can get something like what I will call, it's not a term I use in the paper, the forcing effect. So one must have public officials who are willing to force issues onto the legislative and political agenda. Otherwise, they give the stamp of legality and thus of legitimacy to what is in substance a charade. Now, I don't think that in order to have this forcing effect, that you have to have a judiciary which has the authority to invalidate statutory provisions. I don't think one has to have a written constitution in place with a Bill of Rights, with judges given the authority to deem invalid statutes or executive action that violates the rights guaranteed in the Constitution. I think that in a common law jurisdiction where there's no written constitution, where judges do not have the authority to invalidate statutory provisions, I think that judges are just as capable in such a jurisdiction of performing this forcing role, making the public take note that in a way, the official commitment to the rule of law of that society is at stake in what the government is doing, and so trying to rein the government in. All that one needs is that public officials insist on making the public aware that the officials are unable to perform their role as one of the institutional guardians of legality. And the reason that I emphasize one there is that in contrast to Schmidt in his papers on the guardian of the Constitution, and in contrast to his obsession with the question of who makes the final decision, who has the last word, so that sovereignty can be located in one institution or person, so the choice is between judges or parliament, or judges or parliament, or the executive. Rather, I think one has to see that all of the institutions of legal order must be understood as participating in the exercise of sovereignty. One doesn't know there's been an exercise of sovereignty till all the institutions have participated in deciding on the content of a sovereign act. And so all the institutions have a guardianship role to play. And when officials in any institution, any of the familiar institutions in legal order, point out explicitly that they are unable to play this role, they're pointing out a problem of legality. And what is that problem? That the society is not living up to its fundamental legal commitments, which is to say, not treating those subject to its laws in a way that respects the subject's interests in liberty and equality. And this I take to be a problem of political identity for that society. So in the end, what I think one has to confront, if one wishes to confront Schmidt's challenge, is his idea of the political. And that's what I think Postuma fails fully, or maybe even at all, to confront. The issue is not, as Schmidt tries to get us to believe, something called the political versus the legal. Rather, it's a contest between what I take to be two distinct conceptions of the political. On the one hand, we get in one, the Schmittian conception, in which, as I put it before, The political is an existential site of conflict between different visions of the substantive homogeneity of the people, and the task of the state is to settle that conflict and then use law as the instrument of the victorious vision. So that's, I take to be a kind of nutshell account of the Schmittian conception of the political. And I think the opposing conception of the political, the liberal conception, is one in which the political is a legally constructed space, both in that groups contend for power on terms set by the order's constitutional commitments, and in that a group that has power exercises that power on condition that the law it makes meets those same commitments. And now at the end of my slides, and I just want, maybe I can do this very quickly. I can go right back to the beginning. And so when Postmer talks in his conclusion to the chapter, Executive Power Unleashed, about a fundamental political ideal, I think we share an understanding of that fundamental political ideal. But I do think one needs to go through the steps that I've tried to go through today with you in order to see why the liberal political ideal that we both share can satisfactorily respond to what I understand to be Schmitt's challenge. I'm now at an end. Thank you.
Okay, thank you. Well, yeah, I think so.
Oh, the camera, camera's down. Can you get rid of
Yeah,
this?
the camera. Yeah. So thank you again, Professor Dyzenhaus. I'm sure the audience will have a lot of questions to make. I just would like to make a very short comment and also add some doubts on what you have said. And the first thing is that something that has always intrigued me when I read Schmitt is the fact that his conceptual ideas are very much connected with his own biography and his own political commitments. So it's a challenge to separate or try to give some accurate meaning of his political commitments, his sometimes opportunism, and also the conceptual force of some of his distinctions. And that's pretty clear. And you mentioned cases in which his ideas were used for normative or political purposes. But it's not that clear when you read some of his articles, in which at least he seems to be faithful to, let's say, to a genuine, authentic intellectual effort to make some distinctions. So the concept of sovereignty is one of them. Sometimes it's clear that, at least on my reading, that he's trying to be very much descriptive, in a sense that he's trying to say, well, whenever we have political communities, we have to acknowledge that political communities can be created by different kinds of relationships, of homogeneity that we can find in different groups. So we can have, for example, political communities based on religion, based on political ideas. So everything could be the cement for this organization of different communities, and for this reason, to be the basis of the friend-enemy distinction. So in a way, I think he's trying to be very realist in his description of this. But when you mentioned, for example, his argument on who should be the sovereign, there there is something that's being added to this mere descriptive point, which is, it seems that he would support any kind of friend-enemy distinction, because any kind of enemy-friend distinction could be the basis for a legitimate government. So in this case, it seems that he's being very normative in the sense that he seems to be supporting that's how things should work and how the law should be understood. Even when we take the very concept of the sovereign is the one who decides on the exception or about the exception or whether we live in exceptionalism, in exceptional situation. It seems that on one hand, we could understand this as a very theoretical, very abstract kind of statement, in a sense that we could understand simply that, well, at the basis of any legal order, at some time, that there has to be some decision, some existential decision, and at the basis, the very limit, this decision that could be based on anything, on prejudice, on religion, whatever, is what creates a new normality. So in his paragraphs in which he discusses the idea of exception, he also puts a lot of stress in the idea of normality. So the exception is the point, is the situation in which you can fully understand what is, let's say, the logical moment for the creation of a normal situation. And I think that he also says, especially in the three kinds of juristic thought, that in many ways the normality could be based on many different social values. In that special article, he says that, for example, the army, the church, and some other political, Catholic, conservative values, he acknowledged to be the values that are the basis of the German political context. Which, even though this is a very also difficult article to be interpreted because it's very much intermingled with his own political agenda. So it's not really the best kind of intellectual effort, pure intellectual effort. But anyway, what I'm trying to stress here is that I think there's an ambiguity in the sense that sometimes it seems to be simply stating what is the logical origin of a new normality and what is the role and how, in a way, law is, in the end of the day, at least in this genetic moment, grounded on a political decision. So this is how his decision is in his conception of law. And it's just stressing there, and in many ways, he's trying to criticize Kelsen for offering a kind of misguided way of presenting the law itself, a degenerated decisionist, as he calls Kelsen, because he, in a way, try not to be so clear, so to put it evident, the political grounding of the law. And in other ways, in other moments, it seems that and you mentioned this debate about the Article 48 of the German Constitution, in which it seems that he's being more normative, that is saying that, oh, listen, if you have to acknowledge who is the one to decide about exception, we should take the Führer as the one who is in charge of doing that, and not the courts. But it's not always that clear. So I was wondering if you think that we could take, even with a lot of care, if you think it would be makes sense to make this kind of separation between the more conceptual Schmitt and the more engaged conservative right-wing thinker Schmitt, and the uses not only that Schmittians made of these ideas, but he himself made of his own intellectual achievements. And finally, so this is my point. First point. The other point is that it seems that even you criticize his concept of the political as well. We have to address this. We could also, you didn't mention, but we could also compare and contrast his own idea of politics, of political, with, for example, Hannah Arendt's conception as the space of the use of arguments and the use of the language as the domain of the political. But even if you say that this is the kind of game of politics that we should encourage, that the legal institutions or the liberal legal institutions should promote or should value, there is still his point that from a very realistic point of view, well, politics in a way could also be understood at the limit as this confrontation between enemy and friends, like as he himself acknowledges in a Clausewitzian view of politics, that the war is the continuation of politics by other means. So why should we, I mean, descriptively say that wars is not politics anymore? Because this is a kind of conclusion that we should have to follow if we take Hannah Arendt's conception of the political to strictly, and in a way, Schmittian conception of politics seems to be very descriptively reasonable in a way, if you want to understand this relationship that maybe it's not a so clear continuum between war and politics, but there's a close and strict relationship between them. And a final point, which is very short, I hope, and I think it is, which is, don't you think that in a way, Schmitt is the theoretician of the exception? And in a way, he tries to understand law from the point of view of this limit case of the exception. But on the other hand, and I think very, very few authors put some emphasis on this, he also stresses that law in general requires an environment of normality. So, and other liberal authors like, I don't know, Dworkin or Postuma, they are basically thinking about situations of normality, because maybe the grammar of law is different in these two situations. Just to give you a metaphor, like, for example, the physics of the middle-sized objects is different from the physics of the very small scale objects, like the quantum physics. So don't you think that there are different grammars in situation of exception and the situation of normality? And we usually think about law and rule of law assuming the situation of normality.
Do I have a week to respond? I'm going to do my best without using up all the time, because that was a set of doubts which pose a lot of problems for the argument as I made it both in the paper and in my presentation to you today, and indeed in all the time I've spent working on this curious fellow, which is really since 1993, I suppose. So quite a long time I've been trying to grapple with Carl Schmitt. So let me see how much I can do without using up all of the time. I think what running throughout the different comments that you made on my paper and on my presentation, there's you want me to distinguish, or you think one should distinguish between the more descriptive conceptual side of Schmidt's arguments and then the normative side. And then the point is, well, he makes use of the conceptual descriptive side when he makes his more normative arguments, but we shouldn't collapse the normative side into the conceptual descriptive side. Why? Because there's something useful to be learnt on the conceptual descriptive side. And perhaps that lesson hasn't been learnt, to go to the very end of your comments, by people like Dworkin, because they assume normality, and Schmidt actually teaches us a valuable lesson in telling us that we also have to have regard to the exception. So that's the kind of summary, I think, version of everything that you said. So let me start with the point about genuine intellectual effort. Was Schmidt making a genuine intellectual effort? Well, I think one can make that claim. People who know Schmidt will know that in, I think it was 1938, he wrote a very interesting book about Thomas Hobbes. And quite clearly, he was a very vain man, regards himself as the Hobbes of the 20th century. I mean, there's a different use of vain. He says at the end, Thomas Hobbes, you no longer speak down the centuries in vain. And what he clearly means is that your efforts are good because I, Carl Schmitt, am the 20th century Hobbes. And this book is interesting because it can be read, and I think should be read, as a veiled critique of the Nazi regime. Because while Schmidt thinks that some of the elements of Leviathan undermined Hobbes's vision, nevertheless, there's something valuable about that vision. And one can see in what he thinks is valuable some sense of his own vulnerability at that time, because he'd fallen out of favor with the Nazi Party, and he was worried he was going to be dealt with just as the Nazi Party often dealt with its enemies. They just did what you liked with him. They did what it liked with them, which, going back to Frankel's distinction between the normative state and the prerogative state, if you ended up in the prerogative state, that was really the end of you. And so he has genuine fear about being extracted from the normative state and being put into the sphere of Nazi prerogative. When Schmidt wrote that book, it was a longer response to a young German called Helmut Schelsky, who'd published a thesis critical of Schmidt, and then a short article which Schmidt responded to initially also in a short article and then elaborated in this book. And Schelsky was a committed Nazi. And after the war, when Schelsky's thesis, which was published as a book in the late 1930s, was republished as a book, he puts forward, he puts into the book a really quite interesting foreword. And he says, well, I was a Nazi then, sorry about that. But he says, you've got to understand that we were academics, we were scholars, we were engaged in a genuine debate with each other. And this was a genuine debate between Schmidt and me. I actually think that Schmidt was a complete charlatan. I don't think there's any genuine intellectual effort going on in Schmidt. I think he takes from classics what he wants. He twists it around to suit his own agenda. I haven't written on this myself, but I've seen work by a young American on Schmidt and Baudin, where Schmidt says one thing about Baudin in one article and another thing about Baudin in another article, just because he's making use of Baudin for different purposes. So while I think that Schmidt's challenge has to be understood and answered, I don't actually have much respect for him as a scholar. So that's a bit of a frank response to that part of your claim. So, but let me try to explain why. So in my work, and I might mention this in the paper, the longer paper that I had circulated, I regard Schmidt as having what I call in my work a negatively prescriptive theory. So I don't know how one would translate, because I know no Portuguese at all, but how one would translate negatively prescriptive theory into Portuguese, but the idea is that Schmidt himself does not prescribe a political vision for Germany in the 1930s or for any society, but he does rule out certain things. So it's negatively prescriptive in that it doesn't put forward a positive vision, but it rules out certain political ideologies. Why? Because his other political ideologies are not really political. They're not genuinely political. And his main target is liberalism. He does not think that liberalism can be a genuine political doctrine. So whatever is put in place, it should not be liberalism. And indeed, when Leo Strauss, who'd had a lot to do with Schmidt, and as a young man responded to Schmidt's The Concept of the Political, a response which is included in the translations of Schmidt's The Concept of the Political, Strauss accuses Schmidt, with whom he's by and large sympathetic, as not being able to see beyond the horizon of liberalism. And I think that for Schmidt, the political foundational decision for a society is anything but liberalism. So I think the ruling out of liberalism from the start, liberalism cannot make the friend-enemy distinction. Therefore, one cannot have an authentically political society that's liberal. And I think that's an argument that he makes within the conceptual descriptive side of his work. And if that's the argument that he makes within the conceptual descriptive side of his work, then the conceptual descriptive side of his work is not conceptual and descriptive. It's driven by his normative agenda, which you see more clearly in his interventions, like in the debate about guardian of the Constitution. Now, there is something to his conceptual descriptive claim. And I took this to be a large part of your reflections on what I had to say about Schmidt. So someone whom I've talked about this week, but who's not in the audience today, Daniel and I share an interest in the work of Bernard Williams. And Bernard Williams, the great English philosopher, has a book of essays, and the title of this book is "In the Beginning Was the Deed." Why in the beginning was the deed? In order to contrast with the idea that in the beginning was the word or reason. And this idea of in the beginning was the idea in the beginning was the deed is that there is going to be some existential fact at the basis of any society. And one can see this, I think, acknowledged in liberalism. So if you're willing to concede just for the moment that Hobbes is a liberal, I know that's often a difficult concession to make. When one gets to the last part of Leviathan, the epilogue and a conclusion, Hobbes says that there's no point looking to the origins of any state in order to understand why states are legitimate. Why? Because the origins of states are always in bloody, violent conflict. And then you get a clear echo of Hobbes's thought when we get to Kant, when Kant says one should never inquire into the origins of state with practical intent. Why? Because these liberal thinkers all concede Schmidt's point that at the beginning of any political order, there's going to be this existential fact. And Williams, in the first, and I think really quite wonderful essay in that book, says that the problem with what he calls moralist theories of legitimacy, and he includes all liberal theories of legitimacy in this description, is that they don't take account of the fact that there have been very few liberal societies in the history of the world, or even looking around the world today. There are very few liberal democratic societies around. So it's a grave mistake to think that if we want an understanding of what makes a political society legitimate, that we should look to criteria offered by any liberal political philosophy, because that would make nearly all societies politically illegitimate. But and Williams actually takes some observations from Schmidt in his arguments, but he's clearly against Schmidt in that he does think that any political order must be able to answer what he calls the first political question, which is a question that he takes from Hobbes, and that is, how do you solve the problem of political disorder in the first place? And for Williams, I think it would be the case, he doesn't say much about this, but it is going to be the case for most liberal Democrats, that part of the answer to that first political question is that if you want to have a functioning political order in place, that functioning political order has to function through a legal order and through the rule of law. And Schmitt wants to rule that out, right? At the beginning of a book that he wrote at this more or less the same time that he wrote the book that you refer to, that is the 3 types of juristic thought. So in his book, Legality and Legitimacy, he says at the beginning there, we need to get rid of the idea of the rule of law, the idea of legal order that goes with that idea. And I think there again, it's not a descriptive conceptual claim. It's more in line with what I called a negatively prescriptive theory. So I think one has to concede that there are going to be political orders that are illiberal, perhaps because they're theocratic or for some other reason, and that people within those societies, or at least a large proportion of them, will regard the order as legitimate if that order is going to persist. And I'm very interested in that kind of question. But I think what Schmitt denies is exactly what I had on my last slide, that there could be a political ideal of liberalism that's in contest with his political ideal. That political ideal has to fail, and insofar as that theme runs throughout his work, I think his work is from the ground up normative. There's an interesting comment which Hayek quotes in one of his books. So Hayek, and I think people often find this strange, but I actually find it interesting, had a lot of time for Schmitt. Yeah. Why? Because Hayek thought that if you really wanted to understand the rule of law, you have to understand the rule of law from the perspective of its enemies. And he regarded Schmitt as the kind of main enemy of the rule of law in the 20th century. And in one of his footnotes, Hayek quotes from an essay by a Nazi lawyer called George Dahm, D-A-H-M. And Dahm says, approvingly of Schmitt, you cannot understand any work of Schmitt's unless you understand it as from the ground up committed to fighting against liberalism. And that's something that I think is right. So just one more response, going to your very last comment about normality and Dworkin. In the book which I wrote on Weimar legal theory, to which I gave the title Legality and Legitimacy as a kind of direct response to Schmitt's book with the title in the 1930s, I point out in the introduction that one can establish some kind of communication between what Schmitt has to say about the exception and contemporary debates in legal theory. And I used Dworkin as the example. So what is, how can one establish this communication between Dworkin's understanding of legal theory and Schmitt? Well, it's through Dworkin's attention to hard cases, right? So if one looks at legal positivism, if we take legal positivism to be HLA Hart's legal positivism, which is what Dworkin took it to be, and Hart's distinction in 1958 between the core and the penumbra. So the core is the normal, the penumbra is the exceptional. In the exception, judges are free to do what they want. So constrained freedom, but within the constraints of that space, they have the same kind of discretion as the legislature has. And what Dworkin does in renaming what happens in the penumbra hard cases is to argue that in hard cases where positivists would say the law has run out and therefore judges have discretion, Dworkin's argument is that it's precisely in those exceptional cases, the hard cases, that one will be able to understand the normal. So what one finds in the exception is the clue to understanding the normal. But his understanding of how that works is, of course, very different from Schmitt's, but it doesn't neglect the exception. He just has a very different view of how to understand the relationship between the exception and the normal. And let me take this back then to Schmidt. So in Schmidt's very first work, which is called Gesetz und Urteil, so law in the sense of whatever the Portuguese word is for lex, lay and judgment. So lay and judgment. Schmidt is obsessed in that work, I think it's his doctoral thesis, with the idea of discretion. And he actually spends, and this is the only time in his work that you find really direct engagement with English legal thought, direct engagement with Bentham and Austin. And Schmidt is very troubled by the existence of the space for judges to exercise discretion. And he argues in the book that the only way you can deal with this space is to require of judges that they make their decisions in accordance with some kind of sociological conception of what's normal. So as I understand that, it's really look what's out there, find out what the people by and large want, and decide in accordance with that. And then Schmidt, I think over the years that lead to his late Weimar writings, becomes more and more bothered with the exception. And until the exception looms so large in his thought that he thinks you need a political intervention at the very top to deal with a state of exception in society. So for him, Dworkin's hard cases turn into the state of exception that he thought one needed the president as guardian of the Constitution to deal with in late Weimar. And I think that there, it's just a gross exaggeration. So when Heller responded to Schmidt, when they were arguing before the court in the coup against, the case that followed the coup against Prussia, Heller says, Schmidt, and I suggested this in my presentation, your understanding of the exception is very peculiar. You're not actually concerned with the state of emergency. You're concerned with this, as it's ordinarily understood, you're concerned with the state of emergency that's presented by having liberalism in place as the dominating ideology within the political and legal order. That's what the exception is for you. And responding to that state of exception is what your arguments are really about. Right. It didn't take me a week, but it took me a long time, but there was a lot there. Yeah, yeah. It could take a week.
Obrigado. Okay. Thank you, David, once again for this last very inspiring lecture. I have a question that might be fit for your final presentation. Today you mentioned on a few occasions your so-called rule of law project, right? And in your book, I believe it's in one of the early pages of the book, you presented as an idea opposite to the conception that law can be described as the gunman writ large situation. Yeah. So, right? So I've been trying to put together what the rule of law project, sort of the nuts and bolts, what it has in terms of this legal machinery. And I got 3 parts, I think, and I want to know if there are any others. So the first, and I'm maybe drawing this from your earlier work as well, I think the rule of law project must be committed to sort of inner morality of law, in the sense that if it's not, it will demanding compliance through something that does not fulfill this inner morality, generality, promulgation, clarity, whatsoever, perspectiveness, will strain the authority of the law. The second is the idea that citizens from whom the law requires obedience must be all taken as citizens of the same class, so as equals. So having second-class citizens also strains the authority of law, and it makes it hard for legal authorities to require legal compliance when they are admittedly or clearly treating some citizens as second-class citizens. And the third, which I think came from your presentation today, is that a rule of law project must somehow deal with the problem of emergency. So dealing with political emergency within the frame of the rule of law must be something that the rule of law project addresses. Is that it? Is that correct? Is there anything missing? Is there, for example, an international dimension to your rule of law project, as your book suggests? You mentioned Kelsen moved up to the first place of your favorite jurists. Now that you understand him as having dealt with the problem of international law and the relationship between municipal and international law in a better way than other jurists. Is there anything missing from the rule of law project? Did I get all the points, or is there something, or are those correct? Or am I wrong in any of them?
Yes. So I started to nod when you identified the first three elements, but in a way I was nodding at myself, 10 years ago, before I rethought my views on Kelsen. And certainly, I think number 4 has to be there. Why does number 4 have to be there? Because I think in order to understand states as legal states, one needs a conception of international legal order that constructs states as legal states. And that's principally, I think, what I want to take from Kelsen. Not all that I want to take from Kelsen, but that's the main change in my thinking is that through dealing with parts of Kelsen that I hadn't dealt with in past work at the time. I was just obsessed with the Weimar era debates between him and Schmidt and the other person I mentioned, Hermann Heller. I didn't take account of this international dimension. So number 4 has to be there. I wanted to say just a little bit about number 2, taking citizens as equal. And something problematic happens when citizens or subjects are treated as second-class citizens. And I wanted to say something about that just because it goes to some of the parts of your comment. So particularly problematic for my understanding of the rule of law is how any state legal order deals with immigrants and refugees, people who want to be part of the political community but aren't yet part of the political community. And I think that this kind of issue really presents a problem for any rule of law project, because immigrants and refugees are not going to be treated in the same way as people who've acquired citizenship or whatever the equivalent is of permanent residence within the country. And so the reach of the rule of law might not be as extensive when it comes to these people, the others, who present a kind of exception to the legal order. And so I think it's incumbent on any account of the rule of law to be able to show how it can deal with this kind of issue, which is, of course, an issue that's of great importance today. So I think I say that in order to acknowledge that as committed as I am to this idea of a rule of law project, it encounters huge problems in responding to the challenge of the exception, however that challenge is put. And perhaps one has to maintain a kind of faith that it can respond to these kinds of problems if one also wants to be committed to liberal democracy. And part of what I wanted to suggest today is that I think it's problematic to give up on that faith by saying, well, they're just going to be exceptions. And when it comes to exceptions, the liberal democratic order should respond in a way that's not consistent with liberal democracy.
Yeah. So we are short on time, so I think I've counted 4 other people wanted to make questions. Yeah, I counted all. So 5. So I think we better go in packs of 2, maybe. So Arthur and Rubens, and then Carlos and yeah.
So ask and then pass the microphone to Rubens, right?
Yeah.
Okay.
And Danilo.
It's a short question. So thank you for another amazing talk, David. One of the points that interested me the most is when you were mentioning one of the challenges that Schmidt poses to the liberals and specifically to the legal liberals, which is, if I understood it correctly, that their account of the law would end up in a kind of formalist structure that would accept it would be vacuous in a way, and it could be exploited by people who wanted to do things in the space of legality, but ignoring the values that inspired it. And you mentioned Hungary as a place in which this appears to have happened. And of course, our own illiberal example comes to mind, because Bolsonaro was, in a way, a very Schmittian president, I think. He literally said that he's the constitution once, but more importantly, he used to employ this expression in his rhetoric, which is the 4 lines of the Constitution, as 4 linhas da Constituição, which is kind of a puzzling expression, even in Portuguese. I'm not sure what he means by that. But what comes to mind is the idea of this frame, right? So the 4 lines forming a frame, and whatever is inside this frame goes. It's legal, he can do it. His opponents sometimes go outside of the frame, but he never does. And the idea of frame is literally used by Kelsen when he talks about interpretation. He uses the word Rahmen. So what interpreters of the law can do is form a Rahmen, a frame, and that's all interpretation can do. What is done inside the frame is not an act of knowledge, it's an act of will. My question is, how do you respond to that? Do you need perhaps a theory of legal interpretation that's stronger than Kelsen's? Something more like perhaps Dworkin's or Fuller's idea of interpretation, in which legal interpretation needs more than a frame. It needs interpretation that takes principle and values into account in order to give a satisfying answer about what the law requires. Otherwise, Schmitt is right that illiberal leaders can exploit the law in this way.
Thank you, Professor. My question is, how well do you think that Schmitt's critique of liberal legality stands against perfectionist liberal conceptions in which the state has the duty to promote liberal values and not to stand as a neutral part in between parts? I'm thinking of Raz's conception, or even Martha Nussbaum's argument on political emotions, in which the state must promote certain liberal values, such as tolerance and etc. In that sense, I tend to agree that it's important to reformulate or to answer properly to Schmitt's notion of the political. I think that's necessary but not sufficient to address the problem of the fragility of liberal states or liberal legality to authoritarian regimes or authoritarian leaders. Because even if we could formulate a conception of the political, and such as Paul Ricoeur's conceptions, that would still have a state that would be vulnerable to the enemy, adversary rhetoric. So that's my question. Thank you.
Well, thank you for both questions. I may have the same answer to both, so let me see whether I can do that. So, I think that if Kelsen is committed, as you suggested he is, and rightly suggested because he says a lot of things to this effect, to an idea of the Constitution as just this framework, and anything that happens within that framework must be deemed by legitimate by the officials working within that framework, and maybe by the subjects who are subject to the law of that order. Then it looks like what Orban is doing is fine, and perhaps that Bolsonaro had the correct conception of constitutionalism, insofar as one can understand his conception of constitutionalism. So my answer to that is to say, well, Kelsen should not have made those statements. Why? Because his understanding of how legality works was much more complex than this idea of just a framework in which anything can happen as long as it complies with formal criteria of validity. His framework, his understanding of the way legality works was much more complex than that. And one has to see that he was committed to embracing something like Fuller's conception of legality, much as legal positivists in the English tradition, like Hart and Raz, are willing to say, well, yeah, Fuller, you got legality right, and so we are prepared to take that on board. We just don't think that you get anything like an inner morality out of it. I think the one thing that one can't deny is that Kelsen kept away from, as did Hart, any theory of interpretation. Why? Because he thought a theory of interpretation took one beyond legal theory. It's all happening in the space of discretion, and there it's a matter for political theory, if you like, to try to say how judges should decide what Dworkin called hard cases. But if one brings Fuller into the picture, and if it's the case that not only the English positivists, but also Kelsen must embrace something like Fuller's principles of legality, then at least one's theory of interpretation, if one's going to be a judge faithful to one's role in upholding legal order, at least the judge has to try to uphold those principles of legality. And if one has that conception of interpretation, then judges in a state of emergency or state of exception must try to show how what the state is doing is consistent with the legal commitments that one gets from those principles of legality, and bring to the society's attention if it's the case that the judges think that those commitments can't be met. And I think that's what actually creates the basis for the Rule of Law project to operate. When it comes to perfectionist theories of liberalism, I'm with, as I usually am with, my philosophical guru, that's Thomas Hobbes. I'm actually against these theories. Why? Because I don't think one should inject this kind of telos into a political philosophy. And I think one can go a long way without injecting this kind of telos of perfectionism into one's political philosophy by just addressing the problem that you identified as the fragility of legal order. Because if it's the case that in order to have a properly functioning political order, one that answers what Williams calls the first political question, which he takes from Hobbes, if it's the case that in order to do that, one has to put in place a legal order, and if a legal order requires the kind of complexity that I think one can find in Kelsen, perhaps a little help from Fuller, then I think one can answer Schmitt without establishing a political ideal of the sort that people like Raz and perhaps Nussbaum are after, because one answers them on the terrain of Schmitt's claim that legal order, liberal legal order, cannot cope with states of emergency. So I prefer that to be the terrain on which to fight, rather. So, and going back to my answer to Arthur's question, there is a political ideal at stake there on this terrain. That's a political ideal that I take Postumer to be articulating in my first slide. So I think that political ideal can match Schmitt's conception of the political. One doesn't have to go the extra distance of establishing a perfectionist account of liberalism. In a way, I think that might be playing Schmitt's game, because it leaves unanswered the issue which you raised about the fragility of legal order.
Danilo, o Carlos. O Danilo foi primeiro, depois o Carlos. Yeah. Do you think you can agree on what?
Sure.
Good morning, Professor. Thank you so much for your insightful lecture. I would like to ask you a question that I believe is connected with today and also Monday's lecture. My question is about the challenge that judicial deference may or may not present for the rule of law, especially the judicial deference to the administrative state, either in normal times and in a time of emergency. In your book, The Constitution of Law, you point out that although a full exemption of officials from legal controls violates some core principles of the rule of law, there are very understandable reasons why governments seek to protect public officials from some kind of judicial meddling that can undermine the delivery of statutory programs that officials are charged with administering. On the other hand, in your draft, The Legal Experience of Injustice, and in the related topic of your book, The Long Arc of Legality, you remark as an error the tendency of the Supreme Court of Israel to defer to what it considers to be military expertise when it comes to matters of policy, especially involving security considerations. So my question is, do you see the judicial deference as a feature of the rule of law or as a challenge for it? In general, it is a desirable feature or an undesirable one? In your view, is there a criteria or an account of judicial deference that enable us to see when it stops being a desirable feature and starts being a threat for the rule of law? And using as a reference the Israel example, if it is the case that judges in fact know nothing or very little about national security in comparison with military authorities, do we still have solid reasons to demand that these matters continue to be ultimately decided by courts?
Thanks, Professor. I'd like to preface my question by saying that I'm a mere second semester law student, so I hope my lack of depth isn't too terrifying to you. But okay, talking about the commitment to liberal democracy, and the sentiment that Hand talks about, I thought about how could we keep this sentiment going inside people and to steer away from the law becoming just a something without substance. And it came to mind the quote that is often attributed to German poet Goethe, which is, it says, if you treat people as they are, they will become worse. If you treat them as they could be, they'll become better. And I thought about applying this to society itself and how it's more of, I guess, a psychological quote, but you can, attributing this to society as a whole, I thought of that as a source to reaching more of a virtuous cycle of legality. And the problem I see with this, though, is the conflict that this has a little bit with realism, because if you treat society as not as it is or as it should be, you steer away from realism. So I'd wonder what's the best approach, if we should, how far from realism should we be to reach a sentiment that will keep legality something substantial and not just a cocoon for any political ideology that is perverse? Thanks.
Thank you, Professor. I think we had a Schmittian moment in Brazil during Bolsonaro's presidency, and it was constructed by President Bolsonaro first as a problem of the equilibrium among powers. He insisted that the Supreme Court was exceeding its power. It was playing outside the four lines of the Constitution, as he used to say. And then he implied that the real interpreter of the Constitution was himself, because the president is the people's representative and the people is actually supreme. That's something that he also said. The additional problem in Brazil was that, or in our situation, the Supreme Court is going through some sort of legitimacy crisis too. So you could not adopt the Kelsen position very easily in this debate. And I faced this problem. I'm a journalist. I was writing about this. I wanted to defend the Supreme Court in this situation, but there was this limit. So what was the strategy you would adopt in this situation when you have a president that is actually trying to give a coup of state, and a Supreme Court that is not very legitimate, that suffers in the eyes of the population? What would be the best line of defense?
May I just jump in just to make a little point? Maybe you could clarify. Sometimes Schmitt usually uses the word exception, and you, in many moments, you and in your book you use the word emergency. So I'd just like if you could clarify how you put the two concepts.
So I'll start at the very end. So I use the term emergency because, at least at the point that I started writing about this, people didn't think of things in English as states of exception. They thought of things in terms of states of emergency. I actually think exception is a better term. And I don't know whether people will have noticed this, but the title of the book in which my paper appeared, the longer paper, is called something like States of Exception in American History. So I was invited as one of the two legal theorists to talk about the state of exception. Everyone else was writing about exceptional moments in American history, but the book would not have this title were it not for Schmitt. This just goes to show you how present Schmitt is in academic and also public discourse today. Right, when it comes to deference, here's my quick answer, which maybe is in that book, I forget. But I have a certain, let me put this in a way which is not going to be very appealing. I have a certain claim to fame in Canada as an administrative lawyer. Why? Because I came up with an idea which then got quoted and requoted many times, maybe several hundred times by the Canadian courts, of deference as respect. So I sought to distinguish in a paper between two understandings of deferences. I said there was submissive deference and deference as respect. Submissive deference is when the authority says this is the case, and you just accept that's the case because the authority has said so. Whereas deference as respect requires from the authority an account of the reasons that justify the decision. And I do think that deference is a feature of the rule of law. If it's not a feature of the rule of law, then there's no place for the administrative state in a constitutional democracy. And I think there has to be a place for the administrative state. There has to be a relationship between that state and the judiciary. And that relationship takes the form of deference as respect, which requires reasons. So here's the quick answer to the point about the Israeli Supreme Court. When it comes to matters of security in the occupied territories, there's no requirement of reasons. It's sufficient for the military to say, we thought there was a security threat here, or to offer reasons that are very slim. And there, I don't think one has appropriate deference. So I think one can have appropriate deference. I don't think the Supreme Court has displayed it when it comes to what the military does in the occupied territories. Right, this psychological issue, which I find very interesting. And by the way, never apologize for being a mere second-year student, because your question was excellent, and you should just say your question if I can give you one word of advice. And I do think that, in a way, one has to appeal to people as they could be, not as they are. I'm not sure that this is unrealistic, and perhaps this is the extent to which I can answer your question, which I'm totally unqualified to answer. In a way, I might be totally unqualified to even attempt an answer to your question as well, because I think they might amount to more or less the same question, right? If people as they are, rather than as they could be, have doubts about the legitimacy of the court what is the court going to do about that? I think that the court has to appeal to people as they could be. Ask them, are you really committed to having a society that's ruled by law? And if you're committed to having a society that's ruled by law, what do you think that involves? If it involves having a court that's guardian of the Constitution, then you have to take account of that in understanding what you're committed to as members of the society. And perhaps the real problem that I think constitutional courts or Supreme Courts or their equivalent have these days is actually communicating that to the public. So I had a conversation a few years ago at a lunch in New York with a very interesting judge on the German Constitutional Court, where she said that there's a kind of informal judicial group of Constitutional Court judges that get together to talk about, so from Germany, from Canada, from the United States, and maybe from this part of the world as well, I don't know, they get together, and maybe they do this virtually rather than in person, to talk about how they can communicate better with the public in order to give the public a sense of the importance of the role of judges in their society, because they think they have failed miserably in that task. So how to do that is not something I really have any answer to. All I can say is that there is some recognition among judges, at least some small group of them, that there's a problem there and that they have to deal with this problem if they're going to maintain their legitimacy. They can't just go about handing down judgments and expecting the public to understand why those judgments should be taken heed of. They have to be able to explain why it is important that their judgments do have a role in the society in which ordinary people live.
Well, unfortunately, we have to stop. That's our deadline. I'd like basically to thank you very much indeed. It was a really a great opportunity, not only to discuss your ideas, but also to share your generosity, your skills, your intelligence, and the opportunity to have this kind of in-person conversation is really, really a very important and a great value for us. Thank you very much indeed. And I'm sure I'm talking for everybody here. We are willing to have you back as soon as possible. And I hope we can do it really soon. Thank you. Thank you very much indeed.